per the Shinde Group, was causing serious turbulence among party cadres for two reasons. The party indicated an intention on the part of the Uddhav Thackeray faction to escalate a simmering dispute to a point of no return. I will show your lordships that the speaker repeatedly violated his constitutional duty as envisaged. My learned friends have taken recourse to some facts, but I propose to deal more substantially with facts and only incidentally with the law, because a lot has been said on the law. To point out, that the fundamental propositions of law which my learned friends have raised in this case, on the facts of this case, don't arise at all. But Mr. Salve has said something on it in his brief submission. I'll just expand a little on it. But essentially, the 2 points of law, as I understand, in sum and substance, what it boils down to is A, the question of deemed disqualification, but to use that term which they've sometimes used and sometimes steered away from. The question of deemed disqualification, i.e., they were liable to disqualification. The disqualification never took actual place, but they were liable to be disqualified. And consequently, as a result of that deemed disqualification, the second proposition of law, and that is that the court must set the clock back, relying mainly on Rana, again, extensively dealt with by my learned friends, Mr. Salve and Mr. Kaul, and set the clock back completely, because the concept of deemed disqualification, since it dates to the date when the acts entailing disqualification took place, are the ones that are relevant for the purpose of disqualification. So you must look at that time. Now, a brief conspectus of facts. Now, as I pointed out earlier, when we were dealing with referral, there's a very short time span, and that's between 21st and the 4th. Well, it's important to note that while discontentment and division commenced from the very inception of the post-poll alliance of the MVA government, the commencement of irreconcilable differences occurred on 21st June. That's the first date. The differences chiefly centered around the disinclination to continue with the MVA alliance, which, as per the Shinde Group, was causing serious turbulence among party cadres for two reasons. The Shiv Sena had entered into a pre-poll alliance with the BJP for the elections held in November 2019, and their voters and cadres were aggrieved by the betrayal of that pre-poll alliance by the constitution of the MVA coalition government, and two, that the party cadres were finding it difficult to reconcile long-standing ideological battles with their coalition partners, namely the Congress and the NCP, and the cadres of the different party in the coalition, far from working in cohesion, were at loggerheads with one another. Now, there are many statements even before the 21st. Ministers of the then Shiv Sena, the joint Shiv Sena, many statements expressing dissatisfaction in public. MLAs have complained about it. So this is all, 21st is the only date which this court has a record of. But it happened much earlier. Now, the first steps, as per the record of this court, that led to the rendering the differences irreconcilable were admittedly initiated by the Uddhav Thackeray Group. But the first salvo was filed on 21st June by the Uddhav Thackeray Group. In its resolution of 21st June 2022, a minority of members of the Shiv Sena Legislative Party in the Assembly removed Eknath Shinde from the post of group of Shiv Sena Legislative Party, of leader of the Shiv Sena Legislative Party. On the same day, the chief whip, one Sunil Prabhu, issued a party whip summoning all members of the Shiv Sena Legislative Party to attend the meeting at the CM's residence on the same day. The removal of Eknath Shinde, this is where it starts, because my Lord Justice Kohli was asking about, could there be no reconciliation? Was there no party forum to resolve these differences? The first salvo that was filed was on 21st June, and it was a very drastic salvo filed. The salvo was you remove him as a legislative leader. After that, it became irreconcilable. Nothing could be done. And I'll tell you, Lordship, what happened afterwards. Those facts are very important as to why the party forums became irrelevant. What was done by the party organization and the party leaders, including people in their party leaders in parliament? The removal of Eknath Shinde as a leader of the legislative party indicated an intention on the part of the Uddhav Thackeray faction to escalate a simmering dispute to a point of no return. Now, neither the resolution nor the whip issued by the chief whip were communicated to any of the Shiv Sena MLAs who were not signatories to the resolution. Eknath Shinde and the other MLAs only learned about the resolution and the whip on 21st June through media reports of the same day. On its part, the Eknath Shinde Group, consisting of 34 MLAs, passed a resolution on the same day setting out various grievances with the party leadership for forming the MVA government and the impact that it had on the party, its organization, cadre, and voters. Now, Lord, all this has been read, so I'm not going to read in detail. But, my Lord, your Lordships will recall that the letter of 21st June was a response by Eknath Shinde to his removal, in which he pointed out that it was not just the legislators, but it was also the cadres who were disappointed. So the organizational disappointment along with the legislator disappointment were both highlighted in that letter of 21st June, which, as I said, was a response to their letter. By the resolution, 34 MLAs reaffirmed Shinde as the leader of the Shiv Sena Legislative Party, removed Sunil Prabhu as the chief whip with immediate effect, and appointed Mr. Bharat Gogable as chief whip in his place. The resolution was sent, this is important, my lord, the resolution was sent and received by the governor of Maharashtra. So the governor of Maharashtra, to answer again, my lord Justice Kohli's, had his first intimation of a simmering dispute on the 21st June. The resolution was sent and received by the governor of Maharashtra, the deputy speaker of the Legislative Assembly, and the secretary of the Maharashtra Legislative Assembly, both by email and a hard copy. The 34 MLAs on the same day, we are still on 21st June, also sent a notice to the Deputy Speaker, Mr. Zirwal, of intention to move a resolution for his removal under Article 179C of the Constitution, read with Rule 11 of the Maharashtra Assembly Rules. And I'll read those rules in a minute, because they are quite important. They deal with the 14-day period notice prior to consideration. And the rule and the article are both mentioned in that letter sent to the governor and the deputy speaker. On the ground that he no longer enjoys the support of the majority of the House and accordingly has lost his right to continue as deputy speaker, in view of the decision in Navam Rebia, the deputy speaker was requested to refrain from acting as deputy speaker till such time as he could prove the support of the majority in the House. Now, what are the contentions of the petitioner? First, that if the respondent had a grievance with the party leadership, he ought to have sorted it out within the party and not sent the notice under Article 179C to the deputy speaker. That the notice of the deputy speaker was flawed because in any event, the deputy speaker's disability under Article 181 commenced on a consideration of the notice of a resolution was removal and not when notice had been given of the intention to move the resolution under Article 179C. The decision of Navam Rebia to the contrary needed reconsideration. And the resolution of 34 MLAs of Eknath Shinde Group was without jurisdiction as Eknath Shinde had been removed as the leader of the legislative party in the House. That's by their letter of 21st June. Now, this is the response of the... As regards the reply to 2.1 above, the question of resolving grievances against the leadership within the party did not arise, as the party leadership had precipitated the issue and made any reconciliation impossible by unilaterally and illegally removing Eknath Shinde as leader of the legislative party. Well, no hearing, no notice, nothing. This unilateral removal had to be viewed as a hostile act, which would be followed by more serious consequences. In the circumstances, the letter to the Deputy Speaker under Article 179C was a protective step against any escalation by the Uddhav Thackeray group. Significantly, at this stage, now this is important, the Eknath Shinde Group did not take any step in the direction of unsettling the government by withdrawal of its support, necessitating a floor test. Now, my lord, on the applicability of Nabam Rabia. But although on facts, it's my respectful submission that Nabam Rabia's the case doesn't arise at all on the facts of this case. Nevertheless, my lord, if your lordships do intend to say something about Nabam Rabia, my lord, it is my respectful submission that it should be to reaffirm, especially Justice Mishra's view. My lord, I concede that the then members' part of 179C has been wrongly construed, particularly in view of the Constituent Assembly debates, and particularly the view of Dr. Ambedkar in that. But, my lord, there's much more to be said apart from the then members' part of it, for reaffirming Justice Mishra's very eloquently put view in that separate judgment. On the applicability of Nabam Rabia, the construction of that judgment regarding the time when the Speaker's disability under Article 181 commences was established law by a constitution bench, and the Deputy Speaker was bound to act according to its dictates. Well, that's an aside. In any event, whether you like Nabam Rabia or not, the Deputy Speaker was bound by its mandate, and its disobedience at that particular point of time is a serious breach on his part of his duties and the role envisaged for him by the Constitution, impartiality, and of course, obedience to the law. As regards the correctness of the view taken on this aspect in the decision in the Nabam Rabia, it is respectfully submitted that this honorable court should reaffirm the view in Nabam, most emphatically enunciated by Justice Mishra, that when there is an expression of intention to move a resolution. Well, may I just read paragraphs 236 and 238 of Justice Mishra, just 3 paragraphs at this stage. It's PDF 1167. Well, because, my lord, he makes the case for what he says compelling. (236). In this regard, lordships got it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred adjudicatory powers on the Speaker. While deliberating on the constitutionality of said schedule, the majority in Kyoto's case has stated, the Speaker Chairman, while exercising powers and discharging functions under the 10th schedule, act as tribunal adjudicating rights and obligations under the 10th schedule, and their decisions in that capacity are amenable to judicial review. However, having regard to the constitutional scheme of the 10th schedule, judicial review should not cover any stage prior to the making of a decision by the Speaker's chairman. Having regard to the constitutional intent and the status of the depository of the adjudicatory power, no quia timet injunction actions are permissible. Now, I'm not pausing there for a minute. If there is a constitutional violation by the Speaker, the actual order of disqualification, that is not contemplated by Kyoto's judgment. For instance, when he did not comply with the notice period, and that notice period is under Rule 8 of the 10th schedule, a court could intervene, because that was a denial not only of natural justice, but a contradiction of the rules framed by them in their wisdom, under Rule 8, under Clause 8 of the 10th schedule. And Kyoto says something about the sanctity of those rules. I'll come to that later. At para 6.1 of the 10th schedule, to the extent it seeks to impart finality of decision of the Speaker's chairman is valid, but the concept of statutory finality embodied in paragraph 6.1 does not detract from the abrogate judicial review under Articles 136, 226, 227 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malafines, non-compliance with rules of justice, and perversity are concerned. But Kyoto says more on paragraph 8 rules, and I'll come to that. The rest of that is, your Lordship may just see J, that contention that the investiture of adjudicatory functions in the Speaker as chairman would by itself vitiate the provision of the ground of likelihood of political bias is unsound and is rejected. The Speaker chairman hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to and do take far-reaching decisions in the functioning of parliamentary democracy. Vestiture of power to adjudicate questions under the 10th schedule in such constitutional functioning should not be considered exceptionally. Now comes Justice Mishra's own enunciation. The aforesaid reasoning eloquently speaks of the power, position, and the status the office of the Speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and restricted it to the stage, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority stroke jurisdiction, exercises the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional values sustain democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. My Lord, when I show the facts of this case as subsequently transpired, I will show your Lordships that the Speaker repeatedly violated his constitutional duty as envisaged. The Speaker, when functions as a tribunal, has the jurisdiction authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible.